Companies Act, Section 338, Liability arising from failure to maintain proper books of account prior to winding up. Section 338 of the Companies Act, 2013 imposes penal liability on officers of a company for failing to maintain proper books of account in the period immediately prior to the company's winding up. The section aims to ensure that companies keep clear, detailed, and accurate financial records so that, in the event of insolvency or winding up, the financial affairs of the company can be appropriately examined. Failure to do so, unless justifiably excused, results in significant criminal penalties for the responsible officers. 1. Purpose and scope of Section 338. This section is triggered once a company enters into winding up, i.e., the process of dissolution by the tribunal, and a retrospective examination of the company's bookkeeping practices is conducted. Its key purpose is to ensure that companies, especially those approaching insolvency, maintain transparent and verifiable accounts, which are essential for evaluating financial performance, determining liabilities, tracing company assets, and facilitating fair distribution among creditors. If a company has not maintained such books over a defined historical period, the officers in default become liable unless they can prove they acted honestly and the failure was excusable. 2. Relevant time period for maintaining proper accounts. The obligation to keep proper books of account is examined over one of two periods, whichever is shorter. The 2 years immediately preceding the commencement of winding up, or the period from the date of incorporation of the company until the commencement of winding up, if the company existed for less than 2 years. This ensures that even newly incorporated companies are not exempt from the duty to maintain accurate financial records. 3. Who is held liable? Officers of the company who are in default during the relevant period are held responsible. This may include directors, key managerial personnel, managers, or any person in charge of finance or accounts, any other officer who has a role in or oversight of financial record keeping. However, liability is not automatic. These officers have the right to defend themselves by proving that they acted honestly, and the failure to maintain proper accounts was, given the specific circumstances under which the company operated, an excusable default. Only when this defense is not successfully established will penal consequences follow. 4. Punishment for failure to maintain proper accounts. Officers found guilty under this section face stringent penal consequences, which reflect the seriousness of the offense. The penalties are imprisonment for a term not less than 1 year, which may be extended up to 3 years, and fine of not less than 1 lakh rupees, which may extend up to 3 lakhs rupees. These penalties underscore the importance of maintaining proper accounts not only for corporate governance but also for regulatory oversight during insolvency. 5. What constitutes failure to maintain proper books? Under subsection 2 of Section 338, the Act specifies what is considered to be a failure to maintain proper books of account. This includes the following situations. A. Absence of books necessary to explain transactions and financial position. Books of account are deemed to be improperly kept if the company fails to maintain such books as are necessary to exhibit and explain its business transactions, and records are missing which are essential to reflect the financial position of the company. Specifically, companies must keep books recording daily cash transactions, in sufficient detail, showing all cash received and all cash paid. The absence of these records makes it impossible for stakeholders, example, creditors, the tribunal, or the liquidator, to ascertain what happened to the company's funds. B. Inadequate inventory and sales purchase records in case of goods-based businesses. In the case of businesses involving dealing in goods, proper accounts must include statements of annual stock takings, detailed records of all goods sold and purchased, including description of goods, names, details of buyers and sellers, information sufficient to identify specific goods and transactions. 6. Why this provision matters. Ensuring financial transparency, holding company officers accountable for basic governance failures, facilitating the work of liquidators and tribunals during winding up, protecting creditors and shareholders from fraudulent or negligent conduct, enabling forensic investigation into company conduct leading to insolvency. 7. Illustrative examples. Example 1. A private limited company engaged in manufacturing shuts down and is ordered to be wound up by the tribunal. Upon examination, the liquidator finds that no cash book or ledger has been maintained for over a year. The finance manager and managing director, unless they can justify the lapse, are liable under Section 338. Example 2. A retail trading company maintained only general sales summaries but failed to maintain stock registers or records of goods purchased. As a result, during liquidation, it becomes impossible to reconcile inventory and trace assets. Officers responsible for accounts may face punishment. 8. Defenses available to officers. Officers can avoid liability if they prove they acted honestly and in good faith. The failure occurred due to circumstances beyond their control, such as destruction of records due to natural disaster or data breach. The business of the company was conducted in a manner that made the lapse justifiable or unavoidable. The burden of proof lies on the officer to demonstrate that the default was not willful or negligent. For more details, contact us.